You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 7, the patent application process, what happens from after I file until I get my patent issued. My name is Dr. Adam Diamond, founder and owner of Diamond Patent Law in Los Angeles, California, and I can be contacted at patentingforinventors.com. That's patenting, F-O-R, inventors.com, and contact me if you have any questions related to patenting or intellectual property in general. In this episode, I'm going to be going over the process that happens from when you file your application to getting an issued patent. There are lots of twists and turns that the patent application takes, so I'm just going to be going over the basics of the interactions you might have with the patent office once you file your application. In later episodes, I'm going to be going over some more of the details of how to respond to the patent office and other things that might happen to your patent application. The patent office is officially called the United States Patent and Trademark Office, or USPTO. So when I talk about the patent office or USPTO, I'm referring to the same thing. So you file your application with the patent office, and you have to pay some fees when you do that. The fees are about to change, so you always want to look them up on the patent office website. But for small inventors, it's going to be usually between $400 and $730, and that depends on what your income is. But you need to check the patent office for current filing fees, which include filing fees, search fees, and examination fees. You're going to want to file electronically through the USPTO website because it's less expensive and it's just easier than doing paper filing. I'll go through all the steps of actually filing the application and the forms you need and how to fill out these forms in your application. Once you file your application, you immediately get an application number and a confirmation code. You'll want to keep those so you can log in and access your patent application file. A few weeks later, you're going to get an official filing receipt. This doesn't mean that they looked at whether your invention is patentable. They're just looking to see whether you filed it right and you filled out all the forms correctly. So how long it takes to actually get a real response from the patent office depends on the type of invention you have, but currently the average is about 16 months. I've gotten responses from the patent office in as early as 3 months, but I've also waited over 30 months, so it really depends on a lot of different factors. There are a few ways to speed this up, which I'll cover in later episodes, and it usually requires paying more money to the patent office to get your application expedited and filling out some forms. The patent office sends your application to a patent examiner that specializes in the types of inventions that you're trying to get a patent for, and that examiner will conduct their own search to see if your invention is patentable. After 18 months from your filing date, your application is usually made public so that anyone can read your application. Usually a patent application is published before you get your patent issued because the whole patenting process usually takes more than 18 months. In an ideal world, the patent examiner looks at your patent application, thinks it's patentable, and issues what's called a notice of allowance. You pay the issue fee to the patent office, which for small inventors is going to be either $480 or $240, depending on your income. And that can change, so always check the patent office website. And a few weeks after you pay your issue fee, your patent will issue. Even though I've said before that a patent lasts for 20 years from the filing date, you do have to be aware that you do have to pay the patent office to keep your patent active. If you don't, your patent will expire before the 20-year date. You have to pay what are called maintenance fees, and you have to pay these at the 3.5-year, 7.5-year, and 11.5-year marks from your patent date. And this ranges from a few $100s to a few $1,000s. Once you finish the 11.5-year maintenance fee mark, you don't have to pay any more fees. So like I said, in the ideal patent world, the examiner is going to look at your application, thinks it's worthy of a patent, and it gets issued. But this usually doesn't happen. I'd say 90% of the time, the patent examiner will find some reason to not issue your patent, and this is where all the twists and turns happen in the application process. All the details of what to do if your application gets rejected is found in what is called the Manual of Patent Examining Procedure, or the MPEP. You can find it online, and it's over 3,000 pages long if printed out, and it's not a very user-friendly guide at all. There's a reason why registered patent attorneys and registered patent agents are the only ones that are allowed to file an application on your behalf. And it's because it's a very complicated process and you have to pass a specific test on understanding the MPEP. Now, I have mentioned both patent attorneys and patent agents, and the difference between the two is that a patent agent is someone who has passed the patent bar examination that is not an attorney, And a patent attorney is someone that has passed that same patent bar examination, but is also an attorney that has passed a state bar examination to practice general law as well. In order to even qualify to take the patent bar examination, you have to either have a science or engineering background. And this is why most regular attorneys aren't even qualified to become patent attorneys, and why they can't file applications on your behalf. If you want to file an application by yourself as the inventor, then you don't need to take the patent bar examination. You can just file it yourself. Both patent agents and patent attorneys can file applications on your behalf, but only the attorney can do other patent-related things for you, such as help you with your contracts, or give patent legal opinions, or draft licenses, or other things that you might want that are related to your invention. So as I said, what usually happens when a patent examiner reviews your application is that the examiner is going to find some problem with it. There could be tons of different kinds of problems, and I'll go over each of these types in separate episodes. The examiner might say that your application has more than one invention in it, which isn't allowed. She might say that it's not a novel invention, or it's just an obvious improvement. She might say that you haven't adequately described your invention. It could be lots of different things. You will get a letter from the patent office called an office action, which explains why your application has been rejected, and you usually have 3 months to respond, or 6 months if you want to pay some late fees. And after that time, if you haven't responded at all, then it goes abandoned. The most common kind of rejection that I see is an obviousness rejection. If you get one, you might look at the office action and actually agree with the examiner that your invention doesn't deserve a patent because it's obvious over the prior art. Maybe the patent examiner found something that you were completely unaware of and actually convinced you that your invention doesn't deserve a patent. If that's the case, you can just ignore the office action and your application will go abandoned. You have two other options. One is that you can respond back to the examiner and argue why your invention isn't obvious. Maybe you'll be successful, and after you file the response, the examiner will agree with you and send out a notice of allowance. The other option is to change what you are claiming your invention to be by amending the claims. And then you'll argue to the examiner that your modified claims deserve patent protection. You have to do all this in writing, but if you want, you can have a telephone or in-person interview with the examiner to help you out. It's possible that even after you change your claims and argue to the examiner that your invention should be patentable, that the examiner will still not agree with you and issue a second rejection. The second rejection is usually called a final office action, but don't be fooled by this word final. There are very few things that are actually final in the patent office. When you hear the word final, what you should be thinking to yourself is, the patent office wants me to pay more money. So you can pay the patent office more money to have the examiner keep reviewing your application. And when you do this, it's called a request for continued examination, or an RCE. And currently the patent office fees for this are between $300 and $1,700. It depends on the size of your company, your income, and how many times you've made this request. And this doesn't include any attorney fees if you want someone to make all the changes and arguments for you. You can keep getting rejected and keep paying money for as long as you want, but at some point, you'll probably come to the conclusion that you're never going to convince the examiner that your invention is patentable. So you can either abandon your application, or what you can do is appeal the rejection to the Patent Trial and Appeal Board, which is known as PTAB. There's some other steps that you could do in between the patent examiner rejecting and appealing it, and I'll cover those in later episodes. If you do appeal, what happens is your patent examiner is no longer making the final decision about whether your invention is patentable, but it goes to a board of 3 patent judges. You make your argument to the patent judges about why the examiner was wrong and why you should be able to get a patent for your invention. And the board may agree with you and your patent will issue, or the board may agree with the examiner, which is called affirming the decision, and say that your invention still isn't patentable. If you still believe that your invention should get a patent and that the patent examiner and PTAB, they were wrong, then you could appeal the board's decision to either the United States Court of Appeals for the Federal Circuit, or you can file a civil action against the director of the patent office in the United States District Court for the District of Columbia. If the Federal Circuit or District Court affirms the rejection, then in theory, you can appeal to the Supreme Court of the United States, but this is extremely rare that the Supreme Court will consider your case. So in practicality, whatever the Federal Circuit or District Court decision is, that's going to be the final decision on whether you will get a patent for your invention. There's so many twists and turns in the patent application process, which is why there are over 3,000 pages in the manual. So this episode barely scratched the surface of what goes on between you and the patent office, and I'll cover some more of these details in later episodes. But until next time, I'm Adam Diamond of Diamond Patent Law, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.